my YouTube channel Tahir Tech. Today's our topic is when does maritime law apply? Perhaps most obviously maritime law applies to events that occur on high seas, accidents that happen beyond the territorial water of any country. Furthermore, maritime law applies to the territorial seas which are water within 12 miles of the shore. However, the law's applicability becomes less clear further inland. Early in US history, maritime law did not apply to incidents that occurred within the body of the country and therefore excluded incidents involving the Great Lakes and non-tidal inland waterways. However, throughout the 19th century, this exclusion eroded away. Maritime law is now applied to navigable waters. A waterway is deemed navigable if by itself or by uniting with other water. It can serve as a continued highway over which commerce is or may be carried on with other states or foreign countries. Consequently, if a body of water is completely landlocked which within a single state, then it is not navigable for purpose of admiralty jurisdiction. However, a body of water does not need to flow between states to be deemed navigable. A body of water may be deemed navigable if it is a link in a chain of bodies of water that can be used to service interstate commerce. Ultimately, the test is that the commerce of one state must be capable of being carried into another state or a foreign country. Once this test has been passed, it is likely that maritime law will be applicable even if it is a recirculation vessel. Jurisdiction is in maritime law cases. In the US, jurisdiction over admiralty law matter was originally even to the federal courts. However, today most admiralty cases can be heard by both state and federal courts under the saving to suitorial clause in title of the United States in the United States Code 28 USC 1333. The exception to this is any matter involving maritime property. Those cases may only be tried in federal courts. If a state court presides over an admiralty case, the court is required to apply admiralty law, maritime law as it applies to employers. Maritime law as it applies to employers. Under general maritime law, ship owners are required to keep their vessels maintained per a certain standard as the employer and owner. The vessel holder must preserve the safety and structure of the ship in a way approximate for all employees on board. Manning, equipping, and supplying the vessel are all the key aspects of a ship owner duty per maritime law. Subsequently, if an employee of the vessel becomes injured or ill due to a ship unseaworthiness, the owner will be held accountable for any loss. How does maritime law provide for hard workers? Without maritime law, injured seamen would be left on their own with the suffering they sustained while working. Anytime a ship employees become injured or sick, the vessel owner is required to reimburse their losses. Maritime law refers to this reimbursement as maintenance and cover, meaning that until the seamen fully recover, the employer must provide for their obligations. The court views these obligations as an unquestionable duty that the ship owner owes any seaman board their vessels. Seamen are also eligible to recover full wages for the length of the voyage during which they sustained injuries or illness. An employment contract may dictate the amount of unearned wages a seaman can receive. Incident that require Texas Maritime Accident Attorney. Houston Maritime Injuries Attorney exists to help injured seamen or docks workers get the compensation they need to recover full from serious injuries and afford long-term medical costs that occur offshore that include any accident that occur on navigable water, rivers and ocean and in harbors or docks. Thank you for watching my video. If you like my video, please press the bell icon and also subscribe my channel for the future video update. Thank you so much.